Hello, my name is Jesse Lanshe, and I'm hosting tonight's show on behalf of Arab American Family Services, or AAFS. You're watching an interactive call-in program brought to you live on cable channel CAN TV 21 and online at cantv.org/hotline. During the next 25 minutes, we're going to be discussing the legal aspects of domestic violence, and I invite you to call into our show with your questions at the number on your screen, 312-738-1060. Our phone lines are now open. Joining me tonight is Chicago attorney Jenny Jeltes. Jenny, welcome to the show.
Thank you, Jesse.
You may have seen our episode a couple of months ago. We discussed in detail orders of protection. Well, tonight's show is going to deal mainly with custody and visitation issues. And to start off, tell us a little bit about what custody and visitation remedies are available to people in an order of protection if they're going through a domestic violence issue.
Well, Jesse, oftentimes when there is an order of protection case where domestic violence is at issue, both parents still have a right to have visitation with their children if they are the non-custodial parent. Oftentimes the parties will not be married. Sometimes they are married. Sometimes they are living in the same house, sometimes not. And the court can award certain remedies as to what the arrangement will be while the domestic violence issues are playing out. And custody as to where the children will reside can change based on who the alleged perpetrator is. And that can be a temporary order pending fuller investigation as to what is going on. As far as visitation, even if there is an upcoming hearing or something on the order of protection, if it's not violence against the children, the alleged perpetrator could still have visitation with those children under certain circumstances to protect the safety of everyone.
Okay, well, there's a lot of information to sift through there, especially some important legal concepts. So why don't we start by telling us what is the difference between custody and visitation? Let's start with custody. What is custody?
Custody is who has the care and control of the minor children. There are two types of custody in Illinois, legal and residential. Oftentimes, people who aren't lawyers, misunderstand the difference because legal custody is not having anything to do with where the children live. Legal custody has to do with who has decision-making authority as to important decisions involving the children. In Illinois, those are major decisions that include educational decisions, religious decisions as to what religion the child will be raised in, and health, medical decision making. The court can award joint or sole custody, where both parents jointly make those decisions. That's joint legal custody, or sole legal custody, where the court finds it's in the best interest of the kids that one parent should have the final decision making on those issues.
Okay,
that's as to custody.
Sorry to cut you off there. You mentioned a few different types of decision making: education, healthcare, and religion. So, what would an example be of an educational decision that people might have a difference of opinion when it comes to custody?
Sure. A situation that I often see in my practice is private versus public schooling. That can of course tie over into the religious decision making if the private school is a religious one. However, not only money but concepts of what kind of education is best for the children can come into play there. So oftentimes one parent will find it's just fine to enroll the children in public school where the other parent insists on private. That would be an example of an educational decision.
All right. And similarly with health, I presume that sometimes health and religion decisions get sort of tangled together. You hear a big issue sometimes is blood transfusions or doing operations and such. Can you expand on the health aspects just a little bit?
Sure. With health decision making, it's more than your average cold and how to treat that. You're looking at more major procedures, like you mentioned, blood transfusions. And that would be who has the final say if both parents, say, are in the doctor's office and the doctor needs to know what treatment to prescribe. It can put the doctor in quite a predicament if they have conflicting instructions from the parents. So if the parents can agree, that's great. A hot topic issue right now, which I won't go into, but just mention, is vaccines. Not every parent is in agreement whether vaccines are appropriate. However, in Cook County, at least in the public schools, they're required. That can oftentimes be an issue too that would touch on medical.
Well, you just touched on, and this is an important point, what happens when one parent feels one way about a subject and the other parent feels a different way. If the parents have joint custody but there's a disagreement, how is that resolved?
Family law practitioners typically will put something in the parties' agreement that if they're not able to reach a decision and it's not an emergency, that they will go to mediation, for example, where to keep the cost, the stress, and all of the other, inconveniences away as much as possible before going to court, the parties will attempt to meet with a third party neutral who will help the parties hopefully come to an agreement on the issue. Then, if they cannot come to an agreement jointly, if they do have joint custody, unfortunately, worst case scenario, the decision would have to come before a judge.
The other kind, so there's joint legal custody, but there's also sole legal custody. Does that mean that the sole custodial parent can just do whatever they like, and there's no recourse for the other parent?
It's great you mentioned that. I think that's a common misconception that people think when they hear sole legal custody, it means precisely that they can move wherever they want, they can do whatever they want with the child, and the other parent has no say. The sole legal custody arrangement only means that person has final say on those major decisions we just talked about. They have the final say on those educational, medical, and religious decisions, for example.
And previously you said that there's two major types. There's the legal custody, but also the residential custody. Tell us a little bit about residential custody and what does that really mean?
Residential custody is just that residence where the child primarily lives. It doesn't mean the child is there every night. It means that during the school year, for example, that's where the child would wake up most every day to have routine and continuity in their life. And the residential custodian is the parent that's usually listed as, the custodian, the one who claims them on taxes, for example, and that sort of thing. Now, it does not impact the visitation rights of the other parents. It's just a designation of where they primarily reside.
Folks, if you're just joining us, this show is in association with Arab American Family Services. I'm placing their contact information on the screen. If you or someone you know is going through a domestic violence situation, please feel free to contact them at the number listed or at the email address listed on your screen. Jenny, are there different kinds of ways that parents can spend time with their children? As far as, will the parents spend most of their time with mom or most of their time with dad? Is there sort of a typical scenario that comes up time and again, or is it every case is different?
I would say there is a majority of cases where you have two parents who can cooperate reasonably well, and if they don't live too far from each other geographically and get along, I think a more common arrangement is where the non-custodial parent will see the children every other weekend, whether that's Friday to Sunday, Thursday to Sunday, and then perhaps a weeknight, like another night during the week. That gives the child an opportunity to show the other parent what they're doing in school, see the parent when they're not just playing on the weekend. And I would say that's common. However, there are all sorts of other situations. Oftentimes one parent lives out of state. In that case, the court will understand that parent cannot come and see the child every other weekend. So oftentimes there's modifications so that the child would spend significant time with that parent during the summer and extended breaks, that sort of thing. And there's all sorts of other ways to modify it that works for the party's unique needs.
I've heard sometimes people can go maybe 1 week with the child and then the next week with the other parent, or a couple days on and then a couple days off. But of course, people have to take in mind things like practical considerations, like school and the school district that you live in. With regard to setting custody and determining who is going to have legal custody or physical custody of the children, what is the standard let's say that the parties cannot reach an agreement on their own? What is the standard, and who makes the decision, and how does that go?
Well, Illinois law provides that in a custody case, the court must do what's in the best interest of the child as far as who will have custody. And that's obviously a broad term. One party's view of what's in the child's best interest oftentimes conflicts with what the other party thinks. So a court will look at a list of factors that is not all-inclusive, but among those factors the court can consider many things. It would consider the desires and needs of each parent with what they feel is best for the child. It can consider the child's position if the child's old enough, the health and the stability and the background of each parent, for example, whether one has a history of any domestic violence or a history of any criminal background or anything that could negatively impact the child rearing. The court really does have a lot of discretion to take all these factors into account and weigh them differently too. In some cases, one factor may play much more heavily than another.
Oftentimes, when people are going through a court action, it can take several months, if not a year or longer. Is there a mechanism in place to help the children have a routine on a temporary basis?
Yes, unfortunately, in contested custody and visitation matters, they can go on for a long time, and judges see that. In fact, there's now a rule that if custody is not decided within 18 months, the court will set the matter for a trial to give resolution. However, that can still take up to 18 months. To give the children some stability, the court can order temporary custody. What that means is just that. It's an order that states that one parent has custody, but it's temporary pending further order of court until there's whether it settles or if there's a hearing to determine the final result.
Well, it seems like sometimes it can take a very long time. What if the judge enters a custody order and one of the parents doesn't like it? Can that person go, the very next day and ask the judge to change custody from, let's say, sole custody to joint, or do they have to wait a certain amount of time?
They do. They have to wait a minimum of 2 years to change custody, and that is to promote stability for children, so that there is not going to be constant flip-flopping and going back to court. That would promote a lot of litigation, and the party must prove substantial change in circumstances involving the children's best interest. Now, that there is an exception to that rule, that one party has to wait 2 years, and that's if there is serious endangerment to the child. If, for example, their physical or mental health is at risk, whether it's due to the actions of the custodial parent or someone else or something in that environment, then that can be a way to bring it to the court's attention within that 2 years.
Okay. Previously, you mentioned the big major areas where people have authority for decision making on custody, but one of the major ones, even if someone has sole custody, they can't make this decision on their own, and that's removing the child out of the state of Illinois. Can you touch on what factors might be appropriate for the court to consider in that instance?
Sure. Courts don't like to, move children away from two loving parents, especially if they're both very involved. So there is actually a separate part of the law that governs how court will decide these cases. They're actually called removal cases, when one parent wants to remove the child from the state of Illinois. And in those cases, the court will look at the same standard with custody. Is this relocation in the best interest of the child? It is a higher burden for the parent who wants to move the child to prove that. They have to present enough compelling evidence to the court for why it's to the child's benefit to move. And those circumstances can be, by way of example, perhaps one parent can offer a much better future for the child, a much better standard of living, whether that's an educational future, whether it's an opportunity to be with extended family. Those are just a couple of examples.
Again, audience, if you're just joining us, this show is in association with Arab American Family Services. Their contact information is on the screen. And joining me this evening is Chicago family law attorney Jenny Jeltes. So, Jenny, separate from custody is the issue of visitation, or sometimes called parenting time. Can you tell us what is visitation, and how would it come about if people are to go to court?
Sure. First of all, I don't like the term visitation. It reminds me of going to visit someone who's in jail. So I'm glad that the courts and the public has started to embrace the term parenting time instead. But with visitation, that's parenting time, rather. With parenting time, it's just that each parent, the child benefits from time with each parent. Both parents can offer a unique perspective on things and have a special relationship with that child. And parenting time can be awarded by the court in a frequency and duration that is proper. There's a presumption that parenting time with the child is in the best interest of the child and is proper. There's a presumption that that's it's the best for them. There could be exceptions to that, but most frequently a court will find it is in the best interest of the child.
Isn't it true that there's a different standard that the court uses to award visitation or not, based on whether the parents of the child are married or not married?
Yes, there is. And in fact, this is a recent change in the law in parentage court, which is where the parents were not married. The parent who does not have, the parent who is seeking visitation, has a burden to prove that visitation is in the best interest and is best for the child. Whereas if the parents are married, there's a presumption that it is already and it will be awarded. Now that burden to have to prove that can be overcome with evidence that, of course, it's proper. Now it'll be interesting to see how strictly this new change in the law is interpreted. But there is a difference based on marital status, whether the public agrees with that or not. It's what the Illinois legislator has, or I'm sorry, what the Illinois Supreme Court has said.
Sure. Well, it looks like we have a caller. Caller, you're on the air?
Hi.
Hi.
So my question is this. If parents have been accused or have had domestic disputes with one another, but neither parent has ever been accused of harming the child or has never been a danger to the child, does that impact custody agreements or arrangements at all?
Oh, that's a very good question, caller. And I'm going to take you off the air. Thank you for your call. Jenny, what's your position on that? What is the position on if the parents have domestic violence issues between themselves, but they do not necessarily abuse the children or do so in front of the child? How do the courts react to that?
Well, as with any incident of domestic violence, courts don't look kindly at that. However, if the child is not present during any incident of domestic violence, and it's especially if it's an isolated incident, in my experience, I do not find that judges are going to place a whole lot of weight on that, especially when the evidence of who is at fault, of who the perpetrator is something that a court sometimes just does not even want to get into, because that would be resolved in an order of protection case, for example, where that person could seek the remedy they want against their spouse. A court is more concerned in a custody case as to whether that domestic violence between the parents impacts the child. It doesn't necessarily mean domestic violence against the child. It means if the child sees mom or dad with a big bruise on their face, that can affect their best interest. So it depends on the level of abuse, the frequency, and whether the child even sees it. If the child's an infant, for example, how could that possibly impact the infant? They don't even know what's going on.
Sure, and that brings up an important point. Is sometimes the domestic violence does directly affect the child, and in that instance, it might be appropriate to have the parent who is doing the abuse to have either supervised or restricted visitation. Can you touch on what scenario might arise to warrant supervised or restricted visitation, and how does it work?
Absolutely. Supervised visitation is commonly ordered in cases where there is a history of domestic violence or abuse. And supervised visitation can occur in a few different ways. Sometimes a court will find it sufficient enough to have another third party, whether it's a family member or a grandparent, someone who's a little more neutral, be there when visitation is occurring. But it would not be just the parent and the child to prevent any risk of harm or anything. That does not mean it has to take place somewhere else, but that's one way. However, in more serious cases, a court can find that, you know what, it's not even safe for the child to have visitation at mom or dad's home, and that visitation needs to occur in a safe place, where there's a center where the parent can go and spend time with their kids. There's a playroom, and that can occur as well.
Unfortunately, and especially where domestic violence is involved, emotions run high. The parties the parents generally dislike each other, have a negative history between them. Are there instances where one party might use their time with the child, the visitation, to get back at the other party, to abuse their visitation?
Yes, unfortunately, and you are absolutely right, emotions do run very high when going through any legal dispute involving the family. And, parties do that. For example, you know what, I'm not going to take the child back because you said XYZ. That's a violation of a court order if that parent has to bring the child back at a certain time. And it can not only be very frustrating to the other parent, but they're also violating a court order. And if it continues, there is legal relief that can be sought for violating that court order. And there are remedies. Not only can that person bring that person to court to make up for any lost time or to basically scold them for not following the order, a court can award attorney's fees for even having to go to court to enforce that order. So people unfortunately do use visitation. I think it's very sad because kids should not be involved in the parents' disputes.
I agree. Tonight's topic is not child support. However, one common misconception is that child support and visitation are connected, and one has something to do with the other. But that's not really true, is it?
No, it's not. Oftentimes, we touched on visitation abuse. One party will say, you haven't been paying me child support, therefore I'm not letting you see our son or our daughter. That's frowned upon and will be nipped in the bud immediately if that's ever presented in court. If there's any decent attorney out there, they will say that right away, that that's not something that can be negotiated. And the reverse is also true. If one parent is wanting to have more visitation and they're not getting the visitation that they feel he or she deserves, they cannot stop paying child support as a method in which to get more visitation. So it works both ways.
Yeah, I found that's a big question that a lot of people ask me. Well, we are almost out of time. Jenny, I want to thank you for coming on the show.
Thank you for having me.
And do you have in the last 15 seconds or so, do you have any closing thoughts on these issues that we've been talking about tonight?
I just think it's very important that the parties remember that, the law states best interest of the children for a reason. So people out there do have a custody or visitation case. It's very important to remain as civil as possible for the benefit of the child and to try, if possible, to mediate the issues outside of court. I do understand in a domestic violence setting, it can be different, but just make sure you're well informed.
Oh, well, thank you very much for that, Jenny. Again, folks at home, if you have a domestic violence issue or know someone that does, please feel free to contact Arab American Family Services at the information provided. And again, tonight's show has been made possible in part by support from Lanshe Law, LLC, as well as the law offices of Jeltes Limited. Thanks for watching.